Hi, I'm Liz Naumovski, host of Finance is Personal. How many times have you come up with a great idea? I know that I get all of my great ideas just before I fall asleep or sometimes in the shower. And if you're thinking about turning your great idea into reality, it's no secret that it takes a lot of planning, hard work, grit, and sometimes a bit of luck to turn it into a successful idea and even a business. So the big question today is, how do I take an idea and make it happen? And how do I protect myself and my idea so that no one can take it away from me? Now, with the changes under Canada's trademark law, you'll be able to trademark such things as sounds, scents, and even tastes. So joining me today to talk about taking our idea to fruition and explain the options available to protect those ideas is Stephanie Vicari. Stephanie is a partner at Baker & McKenzie LLP and has extensive trademark, patent, and copyright experience. She also serves as co-chair of Baker & McKenzie's Toronto Women's Network Group, where she's been recognized as a woman who has made significant achievements advancing women and promoting gender equality. Welcome, Stephanie. Thank you so much for coming today.
Thank you, Liz.
You know, it's funny, you think of finance as personal and you think of trademarks. However, so many women go into business on their own and they really need to protect themselves and they need to protect their business. So back to the initial question, how do we take our idea to fruition and protect ourselves so that no one can take it away from us?
That's a really good question, Liz. And I just want to start with an example. I have clients who come to me on a daily basis saying, I have this great idea, you know, I want to go into the market. I've told 100 people about the idea. They all think it's fantastic. The first mistake that everybody makes is disclosing the idea.
But just, and that kind of doesn't make sense because you want to take your idea and run it through people and say, what do you think? Do you think it's a good idea? Do you think I can make money? But as you said, that's the worst thing you can do.
It is the worst thing you can do. And it is human nature. Obviously, you can talk to your spouse, significant other, family, or what have you, but you have to ensure, especially in the beginning stages, that the idea is not disclosed. Because there are certain protections in Canada that if you disclose an idea and it's in the public domain for over a year, you cannot protect it. So it is out there and then anybody can use it. So you have to be very, very cautious about that. Another thing is, you know, someone can steal the idea. People with deeper pockets, and I've seen this happen, can just take the idea and then register or apply to register to protect the idea. And, you know, an individual doesn't have the deep pockets to fight this person. So you have to be very, very careful. And as soon as you think you have this great idea, I recommend that they go to an advisor, a legal advisor, or someone who has the onus to keep things confidential.
Okay, so I have a great idea.
Okay.
I woke up this morning and I thought, I've got the perfect idea and I think it's going to make me millions of dollars. What do I do? Walk me through the steps of my perfect idea. Let's call it ABC literacy.
Okay, so you have this idea. You understand where you want to market the idea. You should have an understanding as to what who you're targeting. Go to a lawyer. Go to a lawyer. I constantly consult clients, and we have this confidentiality, so we can't disclose the idea. Go to a lawyer as a sounding board, as your first step. If the lawyer thinks there is something to protect, because an idea per se is not protectable. You can't protect an idea. You can't say, oh, I think this company should do X, but if you don't have any components to back up that X, for example, if there aren't any widgets or if there aren't any processes or unique processes, that idea is not protectable. So you go to the lawyer, they will assess whether there are any components that are protectable with this idea, right? And then if there are components, the next step is to do searches to see if any other third party has in fact monopolized or has protected this idea in Canada, so that you know that you're not infringing on someone else's rights.
So how do you do the search? Do you just go on Google?
No, no. And that is exactly what 99% of the people who come see me do. They'll say, oh, I went on Google search engine. I did not see anything. I didn't find anything. This is so unique. But more often than not, when we conduct the searches, there is something in the public domain. So you have an idea, we have to distill it first. So I'm going to step back. Okay. We have to distill it, and we have to see what component is protectable in this idea. So, for example, if you have an invention, and the invention could be a door lock, right? You can get patent protection for that door lock.
Okay.
And so we would explore whether patent protection is a viable option. And with patent protection, it protects inventions that are useful. So there has to be some utility factor with respect to this invention. It has to be unique. So let's say there's a lock for a child's toy, and you have an idea for a lock for a door, but they do the same thing. You would not get protection for that because it's not unique enough. Okay. It's an obvious extension of this invention. And so what you would have to do is conduct patent searches to see whether or not there are any third parties out there that have a similar invention, and to see if you do commercialize this product, you're not infringing a third-party patent. So we have patents. Another avenue are trade secrets, and this is a really powerful and very cheap way of protecting inventions. A lot of people are not familiar with trade secrets. In the US, it's huge because there have been cases now dealing with trade secrets and the protection of trade secrets, but in Canada, it hasn't taken off as much as in the US. And a trade secret could be something that's patentable, but you don't have to get a patent, and patents are very, very expensive to get. The only issue, though, with a trade secret is that you have to treat it as a secret. You have to protect it. You have to put a number of, confidentiality agreements in place in order to protect the trade secret. And I'll give you an example. KFC's special formula.
Right.
That is a trade secret. Now, I hear, I don't know if this is the case, but I hear that they change their suppliers for different products, or they won't have one supplier supply them all the ingredients because they don't want anybody to reverse engineer that formula.
Right.
Right? So there are a number of cautions in place to ensure that nobody can reverse engineer the trade secret. And so it is a cheap avenue, but you have to be on top of it, and it's only protectable until it's been disclosed or someone was able to reverse engineer the trade secret.
We'll be right back with Stephanie with more talk about copyright, trade secrets, and trademarks right after the break. Welcome back to Finance is Personal. I'm Liz Naumovski, and with me today is Stephanie Vicari. And Stephanie, we were talking about trade secrets. Most recently, the KFC secret recipe that everybody's been trying to figure out.
Yes.
But you said, going forward, there's more to just protecting yourself. There's trade secrets, and the next one is trademarks.
Trademarks. And trademarks is a unique avenue now because there have been so many changes in our trademark legislation that it has expanded the amount of protection that a person can get. And so because the law is just so new, we can be creative at this point in time to protect trademarks. So in the past, historically, trademarks were words, they were symbols, they were logos, yes, exactly, logos, designs. For example, Coca-Cola, that's a trademark. Apple, that's a trademark. The Apple symbol, that's a trademark. The Coca-Cola bottle, they've also protected as a trademark. But in light of this new legislation and in light of the advancements that we're making with our law, you will be able to protect so many unique elements in an invention. So if there's a specific scent so let's say you invented a perfume that has this unique scent and there isn't anything out there. One avenue to protect would be the scent through trademarks.
And how do you do that? Like, I've been trying to wrap my brain around that, because if you look at different perfumes, Coco Chanel seems to be the one that basically instills a lot of memories or thoughts for a lot of people. They grew up with it, or it's been around.
Right.
So, okay, let's pretend it's that one.
Yes.
And you've got something that, as soon as somebody walks by, you know that fragrance is theirs. So how do you protect a scent?
I have to tell you, it's not an easy task. It's very difficult. In light of our new legislation, it's really quite new. But you have to show that the scent, that people do recognize the scent. So you have to provide evidence of extensive use or affidavit evidence of people saying, yes, every time someone who walks by has that scent, I know exactly that is the scent. Or even you would go to perfume specialists who say there isn't a scent out there that has the same components as the Coco Chanel scent. So it is very difficult, but in the United States, and they've had this legislation way before we have, Play-Doh was they got a trademark for the scent of the Play-Doh dough.
Oh, okay.
Right? And this Play-Doh dough, just to give you an idea of how difficult it is, has been around for generations. And it's taken them up till now to get this trademark because they've had to prove extensive sales that people do when they smell that smell, they link it to Play-Doh. So there is a lot of work to do. It's not easy to get a scent trademark. However, I think people should try and do so, given that our legislation is so new that you might sneak through the cracks. And it's not that expensive to do.
So, question, if we're talking about scents,
right?
Food is the most amazing scent.
Right.
Because when you sit down and you have dinner with somebody, with friends, with a loved one, you remember those days, you remember those evenings, or cooking together, or cooking at home. I mean, how many times do you remember your mom's cooking, right?
Exactly.
And it's a sense of home, and it's a sense of protection. How do you protect a cooking scent or a food scent?
So you have to ensure, though, that the scent is unique, right? If it's a scent that has an ingredient that's used in other scents, and it could be your mom's meatballs, or it could be a meatloaf that you have at the local at a local restaurant, that won't cut it. There has to be a unique component to that scent. Right?
It's funny that you said, there's a scent. I know my parents come from Macedonia, and every September, the whole country practically smells like roasted red peppers, right? Because that's the time that they make ayva. I'm sure in Italy, that's the time that they do their tomatoes, right?
Right.
So, if you think about it, a whole country can copyright or trademark a scent because it is associated with whatever special food it is that they've had.
Right. And so that's the balance that has to be made. You can't monopolize something that's common, because what if you do get a trademark for the meatball scent, and then there are all these other foods out there that have a similar scent? You can go after them if you have this trademark and stop them from using that scent. And so the government will take that into consideration, and they won't allow you to get protection for something that should be in the public domain and other people shouldn't have protection for.
What does something like that cost?
So to get a trademark registration generally is around, $1,800, provided you don't have any issues in the process. But to go to the next level and get a scent trademark, you're going to have evidence. You're going to have to put in affidavit evidence. So it'll depend on how much evidence you do put in, but it could range from $3,000 per affidavit. So it could get up there particularly if the scent is not that unique. And you'll get objections from the trademarks office, and then you'll have to file more evidence. But if you think about trademarks versus a patent as well, patents are probably the most expensive intellectual property to get. And we spoke about patents earlier. And a patent could potentially cost you, right from the outset, minimum $10,000 to get. Patents are very, very expensive. And with patents, you definitely have to do the searches. Like we discussed earlier, you have to search to ensure, first of all, that it's unique, that there's nothing out there that has similar components that you're incorporating. You have to ensure that a third party is not using something similar, et cetera. And so those searches can be 10,000 plus as well. So you're talking right from the outset that you're going to have to invest $20,000+ just to understand whether or not you can get protection for this idea that you have. So it is fairly expensive.
We'll be right back after this break with Stephanie, and we're going to be talking more about trademarks and holograms, and we're going to talk about copyrights as well. We'll be right back. Welcome back to Finance is Personal. I'm Liz Naumovski, and today I'm here with Stephanie Vicari, and we're talking about trademarks and copyrights and trade secrets. And we just talked about scents, but now we're going to talk about holograms, right? Yeah. Michael Jackson, there was a hologram concert. Tupac came back with a hologram concert. How do you trademark all of this?
That is huge. And it's going to be very interesting because our new legislation hasn't yet indicated how you can trademark it, but I suspect it's the same as getting a trademark for a scent. So you're going to have to establish some way that it's unique, that's a unique hologram. And I've seen some applications, for example, in other jurisdictions where, you know, a horse galloping is a trademark for a company, and they might, you know, depict that at the end of their commercial or what have you. And so people associate that galloping horse with the product. And so in order to get protection for your hologram, you're going to have to associate that hologram with your particular product or service. So just having a hologram of Michael Jackson, you're probably not going to protect unless that is associated, for example, with the concert or with something else, with another product or service. So there has to be some type of link.
Now, what about a copyright?
So copyrights are very interesting as well. And copyright protects literary and artistic works. So for example, a book or software can fall under copyright. And a lot of people don't appreciate that. So if you develop, and you're a software engineer and you develop some software.
An app,
but the software behind the app. So an app is very interesting because there's so many elements that you can protect. You can protect the look of the app. You know, as soon as you see it on your phone, what does it look like? Those components, you can get copyright protection for the app. You could also get trademark protection for the app, the look. But the software, the source code, you can get copyright protection for the source code. And I have to tell you that copyright, you know, is probably one of the cheapest ways to protect literary and artistic or dramatic work or plays, etc. It costs $50.
Oh, okay. Wow, that's a far cry from 1,800 and 25,000 plus.
Exactly. And so you have to be creative. So when you do go to your lawyer, you know, your lawyer will be creative and say, okay, these are the angles we can protect, because you want to get as much ammunition as possible to, you know, ring fence your idea, all the elements around it, so that you can monetize this idea.
Right. So we're going to talk about monetizing ideas towards the end of the show. But there was another thing I wanted to talk to you about, industrial design.
Right. And so industrial design is, it protects the shape of an object, and it protects patterns. So for example, a fashion designer, sometimes it's hard to protect a dress, right? You can get copyright protection in your plans.
Right.
You know, so all your plans, the patterns, etc. And then if the dress has some type of pattern on it that's unique, you can get copyright protection on that pattern. So then if someone, for example, designs pillows with that similar pattern and is just essentially knocking off your dress pattern, you know, the elements on your dress, then you have this certificate and say, hey, I own the copyright in this, you have to stop.
So when you started describing that, the first thing that popped into my brain was Missoni, with that beautiful knit pattern, right?
Yes.
Because everything they do has that beautiful, wave, zigzag, or whatever you want to call it, pattern.
Right.
So if somebody else was to knock them off, that would be, you know, a knockoff sweater or skirt or a dress or whatever.
Right, right. And there are some nuances with copyright. For example, you can't, if it's something that's going to be sold, you're going to have more than 50 pieces, you might not be able to get copyright protection, but you can discuss those options with your lawyer and, you know, by all means, if your product, if it doesn't even have to be a dress, if it's a product that has just these unique elements to it, you can get copyright protection for some of those, or industrial design protection for some of those.
I guess that would be also like the Louboutin. If you look at the new nail polish that Louboutin has, right? Because nobody else has that beautiful packaging and that beautiful bottle.
Yes, that bottle could be an industrial design, and you can protect it via industrial design potentially, right?
So Stephanie, we've talked about costs, we've talked about trademarks and trade secrets and copyrights, and you know, how do you take this product now that I thought about my ABC literacy? How do I take my product and how do I take it to the market? Like, what are my next steps now?
Okay, so you go to your lawyer, you decide and determine exactly what you're going to protect. You start the process. Now, you don't have to have the patent before you go out in the market. You don't have to have the trademark registration before you go out in the market or the copyright. But you need to have a confidentiality agreement.
Okay.
You know, if you go to, for example, a big monster box store or what have you with your idea and say, hey, I have this idea, and you disclose everything, there is a risk still that they can take it, they can take some elements, so you have to protect yourself. And the way we typically do that is we have confidentiality agreements where before disclosing, they'll have to sign and say, okay, we're not going to disclose the idea. And if they do, you have this document, and it's easier to bring them to court with this document rather than he said, she said, you know, and just basing it on credibility.
Now, how do I monetize all this?
That's a great question. In order to monetize, I recommend that everybody gets some form of protection. So either you get a trademark registration, get a copyright registration. And just to backtrack, you don't necessarily need to get a trademark registration in order to assert trademark protection. And you don't necessarily need to get a copyright registration to assert copyright. You do need a patent. But having those documents are prima facie proof that you are the owner. And it's proof in Canada that you own it throughout Canada. If you don't have a registration, you will have to, particularly for trademarks, you'll have to prove that in every province you have had sales and you've used that mark. But with this registration, it's carte blanche.
Nice.
It's carte blanche. And with respect to licenses, and I do a lot of licenses, having a registration and a license, it's easier to license something with a registration than without a registration. Because how do you include in a schedule what, in fact, you are licensing? If you say, I'm licensing this trademark or this patent, and this is the number, and this is the registration number, it's something concrete. And it assists with global licensing as well. A lot of jurisdictions don't recognize just common law trademarks or common law protection. They want to see something. And if you have it, it's so much easier to monetize.
That's great. Now we've got about a minute left, and
goodness.
we wanted to. I know it's flown by quickly today. I wanted to talk about an example. You and I were talking about, you know, women being on mat leave and coming up with really great ideas.
Right, and I get a lot of women who are on mat leave dealing with their children, and they come up with ideas that, oh, they should have this. It would make our lives so much easier. And a number of these women, without going to lawyers or without getting any consultation whatsoever, go to the store and say, I have this great idea. This is what I think you should develop for children, and I can develop that for you. Well, without a confidentiality agreement, without any intellectual property protection, I've seen stores then a year later develop something virtually identical. These women come back to me and say, but it was my idea. I went to them. I gave them the idea. But honestly, unless you want to spend hundreds of thousands of dollars litigating in court,
right,
and the end result is unknown, there's no guarantee that you're going to win, you've just lost your opportunity there.
So the show has gone full circle. From the very, very beginning, when you said, don't tell anyone, we're ending the show with saying, don't tell anyone.
Exactly. Right? Exactly. Don't tell anyone.
So for all of you out there who are ready to take your great idea to the next level, be sure to educate yourself and seek professional advice. Just Googling your idea to see whether someone else has taken it to the market is not enough. And even if the intellectual property is not commercialized, a third party can own rights to it. Understand the importance of protecting your intellectual property and not inadvertently stealing someone else's. And make sure you ask questions and know that there are laws that can help protect you and your ideas. I'd like to thank Stephanie Vicari for joining me today, and you, our viewers, for watching. I'm Liz Naumovski. Bye for now.